Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hope you guys are having an amazing day. Today, we're going to talk a little bit about Mr. Justin Combs. I'm not sure if you guys are aware, but he is dealing with legal battles on his own. Apparently, Porsche has sued or filed a lawsuit against Justin Combs for unpaid car payments. You heard that right? Unpaid car payments. Let's get right on into it. So, as you guys can see, on June the 5th, a complaint was filed by Porsche Leasing, and we'll go a little bit into that when we get into the complaint. So they filed a lawsuit on June the 5th, 2024. They issued a summons. According to news articles that I have read, he was actually served on June 11th, 2024. They filed the proof of service on June 18th, 2024. He did not respond. And normally, during a certain time period, you do have to file your request for entry for the default judgment. Um, they ended up having a state case status hearing on the 2nd of October, if I gotta scroll back up. But they put that request for default entry again on October 4th. And then they also submitted a request for dismissal. So I'm like, okay, you put in a request for entry for the default judgment, but then you turn around and then also put a request for dismissal. So I'm assuming that they are possibly working some things out. But we'll hop right on into that and I can kind of give you guys the latest scoop. As of right now, they have another case management conference hearing scheduled for December 3rd, 2024. Let's see what else. I believe that that's it on that part. So they ended up filing suit for breach of contract. Everybody knows when you go purchase a vehicle, you sign all of these documents. It's pretty much a contract with you saying that you agree, to pay a certain amount per month for so many months or years, right? So in this case, he wasn't making his car payments, but from news articles, they are stating that it is some type of miscommunication. But let's hop onto this complaint and let's see exactly what's going on and why they are suing. So, what we have here is the complaint that was filed in, let me see what this was, Los Angeles, as you guys can see. And what you see here is Porsche, the plaintiffs is Porsche Leasing, and they're also doing business as Bentley Financial Services. And then we have JDC Holdings Group, LLC, and Justin Cohn. So this is a verified complaint for possession of personal property, as a repossession, a deficiency judgment, foreclosure of security interest with deficiency judgment, breach of express written contract, money lent, and account stated. So I'm not going to get into all of the parties. We are just going to hop into the causes of action. So the first cause of action was the possession of personal property. So it does show on or about January 20th, 2022 in Beverly Hills, California, JDC Holding Group LLC and Justin Combs entered into an agreement with Ogara Coach Company LLC entitled California Vehicle Lease Agreement for the lease of the new 2022 Bentley Bentayga Bentayga V8. And then it has the actual agreement that's attached to that. Um, my question, oh, you know what? It just popped in my head. It's JDC Holding Group, Justin D. Combs, the Cassandra. So he purchased it under his business, and obviously, and a lot of people are doing that. but that's a whole nother different ball game there. Separate segment. The agreement provides that defendants were to make 42 consecutive monthly payments in the payments in the amount of $3,365.23 commencing January 2022. Good googly moogly. That for a car note, that's crazy. On or about January 20th, 2022, Ogara Coach Company LLC assigned its rights, title, and interest in the agreement to Porsche Leasing Ltd., who thereafter provided it to Porsche Financial Services, doing business as Bentley Financial Services for servicing. Pursuant to paragraph 24B of the agreement, defendant understood that he did not have ownership interest in the vehicle unless he exercised an option to purchase. No option to purchase was exercised or has been exercised. Attached here too as Exhibit B and incorporated herein by reference, it is a true and correct copy of the state of California certificate of title indicating Porsche Leasing Ltd. As the lessor and registered owner with the defendant as the lessee of the vehicle. On or about December 20th, 2023, defendant defaulted on an agreement by failing to make the payment due, and plaintiffs attempted to demand return of the vehicle. All right, so he defaulted on December 20th, 2023. He entered into the agreement January 20th, 2022. Mhm. All right, so pursuant to paragraph 22B of the agreement, plaintiffs may accelerate the debt and demand the full amount due under the agreement by be paid immediately. I'm so sorry, y'all. Therefore, there is now due owing and unpaid from the defendant the approximate sum of 172,601.43 plus additional charges pursuant to the terms of the agreement. Interest accrues from December 20th, 2023 at the legal rate of 10% per annum until paid in full. So you telling me from January of 2022 to December of 2023, he didn't make any payments and he didn't think that I'm just confused. By March or May of 2022, I'll be like, okay, shouldn't I be making payments on this? I haven't gotten anything. Like, I don't know. Did he think that he got the car for free? I don't. That's odd to me. Very odd. Plaintiffs have performed all obligations on their part to be performed under the terms of the agreement. Plaintiffs have attempted to make demand upon defendants for possession of the vehicle, and defendants have failed and refused and continue to fail and refuse to give plaintiff possession of the vehicle or contact plaintiffs to discuss the account. By virtue and foregoing facts, plaintiffs are entitled to immediate possession of the vehicle. Plaintiffs are informed and believed and based therein allege that defendants or their agents, employees, blase, have power to possess and control the vehicle. All right, so let's see. It has the parking garage. All right, so it just shows where the vehicle was parked. Um, let's see. Plaintiffs believe that the approximate value of the vehicle is 164,500, and they actually attached the blue book value of the vehicle, and that was as of April 2024. Let's see what else. Plaintiffs have suffered the loss of the use and enjoyment of the vehicle. Plaintiffs have further suffered damages due to depreciation and deterioration according to proof at trial. Paragraphs 21 and 22 of the agreement provides that defendants will pay plaintiffs reasonable attorney fees, incurring and enforcing the terms of the agreement, together with all costs incurred therewith. Yep. So not only are you going to be responsible for the amount that was unpaid as far as your car payments go, plus interest, but you will be responsible if granted reasonable attorney fees for even bringing on this lawsuit. Second cause of action was deficiency judgment. Let's see. It says if the plaintiffs do not redeem the default, plaintiffs will then sell the vehicle to establish any gain or loss after repossession. And this is just like a regular repossession. When they pick up the car, they auction it off, and whatever they gain from that will go towards the car. But if there is a remaining balance due, you will be responsible for that remaining balance. And that's what it is. If now, but here is saying if there is a deficiency, plaintiffs are entitled to a judgment against the defendants for the amount of such deficiency. So that means that if there is a leftover balance and the plaintiffs, not the plaintiff, the defendant does not pay that remaining balance, then they have the right to obtain a judgment. Mm-mm-mm. Third cause of action, foreclosure of security interests. It just says that as a result of the defendant's default, plaintiffs are also entitled to enforce its security interests in the vehicle by judicial foreclosure of all defendants' rights therein through a public sale by the proper judicial officer. Good grief. California be doing the most. Breach of contract, that's the fourth cause of action. Let's see. And we see that defendants have defaulted on the agreement by failing to make payments when due. The agreement, the amount that is unpaid and is owed is $172,601.43 plus any additional charges pursuant to the terms of the agreement, and any interest that accrues from December 20th at the rate of 10% per annum until paid in full. So that means each year they're going to tag on 10% to the total sum that is due. Let's see. Then it says fifth cause of action, money lent. It says within the last 4 years, defendant became indebted to plaintiffs in the sum of $172,601.43 plus additional charges pursuant to the terms of the agreement for money lent by defendant to defendant at the special instance and request. Despite demand thereof, defendants have failed and refused and continued to fail and refuse to pay the balance due, owning and it was supposed to be owing and unpaid to plaintiffs in the sum of that amount plus additional charges pursuant to the agreement. Then the last cause of action is the account stated, and it's just saying that the account was stated in writing by and between the plaintiffs and the defendants. It was agreed by both of them for that particular amount plus any additional charges pursuant to the terms of the agreement. Defendant has failed, refused, and continued to fail and refuse to pay the balance due, owing and unpaid to the plaintiffs in that sum plus the interest. So, because of those six causes of actions, in a nutshell, Justin and his business signed an agreement to make a monthly payment. Now, how he did not know he was not making payments from January 2022 to December 2023, I just don't get that. You have to have some type of inclination that, like, hey, I haven't made a payment on this car. Let me call them and see, what's going on. Or I don't see, not unless he has people handling it for him. I don't know. And usually if you're waiting till what? That's you know how many years that is? Let that been a non-rich person. 2 months tops. The tow truck is coming. Okay? The tow truck is coming. Good grief. Um, so for the first cause of action, for an order directing defendants or the agents, employees, or contractors to forfeit and deliver the possession of the vehicle to plaintiffs, or if the vehicle cannot be delivered for its value, for damages equal to the rental value of the vehicle, for damages caused by depreciation and deterioration of the vehicle, prejudgment interest, costs of the suit, and any other and further relief that the court deems just and proper. Second cause of action, for damages, the cost of suits, as well as any further relief. For the third cause of action, for an order directing public sale of the vehicle, and that's once they get it back to their possession. Let's see, and to foreclose all of the defendant's rights therein, and to apply the proceeds in the following order. To the cost of taking, keeping, and selling the vehicle, to the satisfaction of damages and interest thereon under their agreement, the cost of suit, and reasonable attorney fees for a judgment against defendants and in favor of the plaintiffs for any deficiency that may remain. So that's the excess amount. So once they auction it off or sell it, whatever the balance is that's owed, then they can go after the defendants and obtain a judgment for the remaining proceeds. And that's all it is. And for the fourth, fifth, and sixth causes of actions, they are asking for damages in the amount of $172,601.43, plus any additional charges pursuant to the agreement, any interest from December 20th, 2023 at the legal rate of 10% until it's paid in full, cost of suit, attorney fees, and whatever relief that the courts seem is just and proper at that time. Who good these people are, one, why you didn't buy the car off? Let's start with that. All right, so let's see. Here is up, that is whatchamacallit. Well, he doesn't even live there no more. So it is the 2022 Bentley Benta- Bentayga V8. I need to look that up to see what that looks like. All right, so amount due at lease or sign. Ooh, $30,000. First, your first monthly payment of this is due on January 20th. So you signed this contract with, and it shows you your due date, your first due date, how many, payments you need to make, and when your payments are due. Whoa, whoa. Child, do y'all see this? Unless oh, boy, I thought they were saying that's your monthly payment. I totally misread that. So your first monthly payment of $3,365.23 was due on January 20th, 2022. You have to make 41 payments of that amount, and it is due on the 19th of each month. Excuse me. So the total amount that you would be paying overall is that much. Disposition fee of 500. So the total number of payments, that's okay. So the dude had to pay 30,000 up front and make a monthly payment of that for 41 months. Let's see, 3 years is 36. So, three and a half, 3 years and a couple of months of those payments. Interesting. Yeah, I'm just kind of going through here to see. This is interesting. So I was like, man, at the end of the day, why didn't you pay for it up front? It could have been several reasons. But the fact of the matter is, This young man, he signed a contract and it clearly states exactly when your payments are due. So I'm not understanding how you just thought that you didn't have to make a payment unless he had, somebody handling it for him. But I mean, I'm pretty sure, yeah, he brought this up under his company. I need to go do that. That's the title. That's interesting. And this is the collections and recovery manager. Baby, they say we got to get that car. Yeah, so I have so many questions. My question is the biggest one that I need answered is how you did not know that you weren't making payments on the vehicle. I need somebody to please answer that question for me because from 2022 all the way to 2023, that just does not make sense. One thing I also want to show you guys, let me get into here. I want to show you this article. Um, so what I have read before I even got on here is that the attorney stated that it was some type of miscommunication. That because if you guys seen, he didn't file an answer. He did not file an answer. So he was served on June the 11th. There was no answer that was placed on the docket. So that's why Porsche was able to file the entry for default judgment. Now, his attorney's argument was that when they served him, well, I don't even know what the proof service because I don't know if they served him actually. He just failed to respond. I don't know, but the attorney is making like they served him, but uh it was at a location that he's no longer at. The story don't make sense at all. But let me read this article to you guys. So it says legal drama continues to plague Diddy's family. Ooh, where'd it go? Oh, I'm sorry, y'all. All right. Legal drama continues to plague Diddy's family, with his son Justin Combs facing a 190,000 lawsuit amid his custody. The embattled rapper remains behind bars in New York following his September arrest and indictment on 3 criminal charges. However, his son's woes begins months earlier over missed car payments. Porsche Leasing Ltd sued Diddy's son for the breach of the terms of their contract in June. They recently petitioned the court to grant a default judgment against Justin Combs, while his legal reps argued that the suit was a big misunderstanding. Please tell me how this can be a misunderstanding. According to reports, Porsche Leasing entered a lease for a new Bentley Bentayga V8 with Justin and his JDC Holding Group. The deal occurred in January 2022, with Diddy's son agreeing to make 42 payments. Actually, it was, well, yeah, 42 payments. The first payment, and there 41 payments thereafter of that amount. However, Justin breached the terms of the agreement when he failed to make payments on December 20th, 2023. The company explained that per their deal, they could demand the entire amount owed if a default occurred. Okay, so are y'all saying he made the payments and he just failed to make the payment on January 20th? Because this does not make any sense. Therefore, there is now due owing. Okay, so that's an excerpt from here. So it's saying from interest accrued from December 20th, 2023. So he has been making payments, but he just failed to make a payment since January 20th, 2023. That makes more sense. That makes sense. But if he knew that he moved and he was no longer at that address, you would think that you will follow up and say, "Hey, here's my new address. Let me make a payment." Porsche Leasing noted that they served Justin with the documents on June 11th at Diddy's Beverly Hills mansion. At the time, his attorney Jeffrey Littman told In Touch the lawsuit stemmed from a misunderstanding on the company's part. Justin did not intentionally skip the car payments. According to Justin's attorney, he did not default on the car lease bills on purpose. Due to an address change, Justin did not receive his bill, which resulted in unintentionally missed payments, the legal rep explained. We are in touch with the creditor and this matter is being settled. And that's probably reason why we saw the motion to dismiss on the docket. The outstanding balance will be paid and the lawsuit will be dropped. The lawyer claimed. Despite his words, Porsche Leasing moved forward with their lawsuit. So at the time y'all claim y'all was working on it, y'all really wasn't working on it. So Porsche said, "Okay, we're just going to go ahead and file our lawsuit." Earlier this week, the company petitioned the court to grant a default judgment of $190,000. No, yeah, 100 $190,000, $226.25 against Justin. The request to recover $172,000 in missed payments and roughly $13,000 in interest and fees. So my question, okay, so now this makes sense. This makes sense now. All right, so he brought the car January 2022. He made payments. Then all of a sudden, January 22nd or 23rd, whatever that date says, of 2023, he missed the payment. And so he has missed the payment since December till the time of the filing. And I am assuming, let's see, I would say October. So December 2023 all the way till early October of 2024, he has not made a payment. The attorney is claiming that because of an address change, he did not receive his bills. At the same now, if they can work it out, that's great. Pay it in full. Get it over with. But my question still stems from the simple fact that if you moved, why didn't you call? You knew that if you were making these payments on a monthly basis, then you would say, "Hey, okay, I moved. Here's my new address. Let me call and make sure I get everything changed over so I can receive my bills to the new address." Or call them and say, "Hey, I moved. Here's my new address." That's number one. Number two, I'm pretty sure they have a login portal where you could go make your car payment because I do that as well. So honestly, that's not, an excuse. Uh, the attorney said that they were going to work stuff out, and apparently they didn't. That's why Porsche ended up filing. But these celebrities go and lease these cars, and I'm not trying to count their pockets or anything, but like if you can't afford a car, why get a car to make payments on it? Just pay the car in full. Yeah. But that's neither here nor there. Y'all tell me what y'all think about this situation. Leave it in the comments below. Don't forget to like, share, and subscribe. Until then, be blessed, and I'm out. Bye.